conflate our love of wanting to be able to make determinations about state law, our love of our authority in regulating what is legal or not legal under Montana state law, with our ability to render federal laws legal or invalid. If we want to challenge federal laws, we still need to think beyond simply furthering a states' rights perspective. That's only going to get us so far. I am going to wrap it up with what I think is a fun example of an individual being able to use a federalism argument to further her individual liberties. In Pennsylvania, a woman named Carroll Bond found out that her best friend had been in a relationship with her husband and had gotten pregnant. Carroll decided that she was going to smear a caustic substance onto the door handle, the car door handle, and the mailbox of her best friend in the hopes of causing some harm to her. Now, Carroll knew that what she was doing was wrong. And I'm sure Carroll knew that what she was doing was probably violating state law. What Carroll did not know is that she was also violating federal law that was put in place to enact an international treaty regarding the use of chemical weapons. Carroll was prosecuted by the federal government. Carroll was convicted in a federal court of violating federal law. Carroll asked the U.S. Supreme Court, "Can I assert the 10th Amendment?" The state isn't riding in on a white horse for Carroll, but she has a right under the 10th Amendment to be able to argue that the U.S. government has overstepped its bounds. These are usually laws that are left to the states. Supreme Court last June agreed with Carroll unanimously that the 10th Amendment belongs to all of us. It's not just owned by the state. It belongs to all of us. So when we talk about what options do we have for challenging the federal government overstepping its bounds, Carroll found a way. She is going to be able to argue that the federal law regarding chemical weapons is too broad. We'll see where that goes. That's still to be discussed. It's been remanded back to a lower court, so still to be discussed.
What's the name of that case?
U.S. v. Bond. That case is U.S. v. Bond. It was heard by the U.S. Supreme Court last February. They ruled last June of 2011, and it's been remanded back to the Third Circuit.
I'll say a few words and then I'll go on. I'm looking forward to opening it up to a conversation with my fellow panelists and all of you. And I want to thank Humanities Montana for the honor to share this stage with the delegates to which, as a constitutional law professor in particular and as a Montanan in general, we're grateful for your work and also to all the other distinguished guests here. One of the great distinctions between our Constitution here in Montana and the federal Constitution here is the Declaration of Rights, which we heard discussed yesterday. One thing that we missed is the Declaration of Rights starts with, and it comes straight from our 1889 Constitution, a declaration of popular sovereignty. And I want to talk about, I think Niki and Stewart are exactly right, that federalism is a protection of our liberties, but one of those liberties is our liberty of democracy, our right to participate in our government and to govern ourselves rather than being governed by people somewhere else, whether those people are legislators, executives, or courts. And so what I'm going to talk about is how federalism helps protect our democratic rights, our rights to popular sovereignty. Jim Lopatch, I think, really set this up very well. He said I was going to talk about it, but he talked about it enough so that I don't need to talk about it. The question really is, then, which we the people is speaking? Where are we the people going to make our decisions? Here in Helena, or in Missoula, or in Washington, D.C.? And it's always good to quote my dean, but the idea of rock, paper, scissors, of having checks and balances, is not only a matter of vertical arrangements between branches of a single government or horizontal, but it's also vertical. And so we have at least 3 levels of government govern us here in Montana. We have the city government or the county government, local level, the state level, and the federal level. And I want to talk about how important it is that those are kept separate for purposes of our democratic values, in addition to our civil liberties values. That delegation, right, we the people give all of those branches of government power. They don't have it without us. And because of that, it's very important that we know which one of them is acting, and we are clear about which one of them is empowered to act in which fields, so that we're not stuck in a position that Niki is in both dealing with Congress and the state legislature and perhaps cities in terms of all of these different governments that are piling on in terms of violating our liberties. One way we do it is say that, well, Congress, you're going to do that and not that. State government, you're going to do this. So Congress, you're going to deal with war, you're going to deal with the national debt. But the state government, you're going to deal with school funding and most of our criminal laws. Local government, you're going to deal with land use and other subjects of the ordinances. It's important then, under that model, that Congress not deal with state and local matters. So the Supreme Court has said Congress has no business passing essentially a rape liability law in the Morrison case. Congress has no business legislating about guns in schoolyards under the Lopez case. That's a local matter. But it's also important all the way down that each of the other branches also, in terms of who we elect there, that those public officials keep in mind what their roles are. And so I think, contrary to Stewart, I think there are risks, there are costs when we have state legislators who are elected. We chose them to fund our schools, set our state budget, deal with our criminal laws, including our drug laws, spending their time, I think Chuck said 100 unconstitutional bills, passing laws that purport to tell the U.S. Supreme Court what to do. And the great thing about our Montana Constitution is we can be even clearer about what job descriptions. I think I view that these documents are public officials' job descriptions. And we can be even clearer about their job descriptions. For example, that the governor has some duties, and the attorney general has others, and the legislature has others. The legislature is not the legal officer of the state. It's not their job to tell the state which cases to bring, for example, or defend. It's not the attorney general's job to decide whether or not to let certain state policies stand. All of these separations of powers vertically help protect we the people by making it easier for us to hold our elected officials accountable. And too much of them holding each other accountable outside of their bailiwick, so to speak, confuses the matter, makes accountability tougher. We don't elect congressmen to be city councilmen, and we don't elect city councilmen to be congressmen. And yet, when a city, and I love my newly adopted home, Missoula, but they passed an initiative talking about corporate personhood, a U.S. Supreme Court case. And the state has passed, various laws, has gotten involved, where it has gotten involved in both federal matters when we've got a budget to fund. And so, as Jeff alluded to my practice experience, I think of this very practically. If we the people, and ultimately it is we the people, the courts generally do not intervene, and nothing's going to change about that. Even during invalidating much of the New Deal, the court was only eating it around the edges, and the current court, which is very protective of federalism, generally does not intervene in federalism laws that tend to be symbolic. Even if it struck down the Affordable Care Act, that would be a big political issue, but it would be quite a minor expansion of the federalism doctrine. So courts, I think we forget that federal courts, of course, are part of the federal government. It's not their job to protect the rights we have as Montanans. And our state courts do protect us as Montanans, but of course, the best way to protect our rights is by voting, by being active and engaged citizens. That's the only way that we can ultimately effectively enforce these federalism things, and holding our public officials accountable for staying to their job description, whether they're in Congress or in our state legislature, but not mixing them up. And a good way to do that, of course, is by having conversations like we're having today and trusting Niki and Stewart's groups in particular to continue them in a thoughtful way and continue to help voters and citizens remain active and engaged. But we the people started this, we the people are the ultimate guarantors of our liberties, and if we're not engaged as the delegates were when they gave us this document, we shouldn't expect any of our public officials to stay true to it.
So let me quickly summarize the three sets of comments. Stewart, of course, is arguing that the accretion of federal power is somewhat unprecedented, that we are at a crisis stage, much as we were at the end of the 18th century. Niki says several things, and I want to summarize those because actually tend to parallel how I thought the conversation would go. One of the interesting things about state sovereignty is that states have the power to increase individual liberty through their constitutions, through legislation. Second thing is that notwithstanding the state's powers and abilities to increase individual liberty, the federal government has the power to restrict what the states can do. And there are some limitations on those restrictions, or on the ability to restrict. That is, that the federal government cannot commandeer state mechanisms to carry out its powers and to carry out its laws. The third thing she mentions is the idea of the carrot. And what I'm thinking about is the carrot with the strings attached, the doctrine that we refer to as conditional spending, the doctrine by which Congress says, we will give you this wonderful pot of money, and the state goes, oh good, because we need some roads, and then Congress says, but. And there are a lot of things that have to do with the but. One of the things that has to do with the but is the rest of the language that are referred to with respect to adult rights. That is, the original provision in the Montana Constitution said that 18-year-olds have all the rights of adults, period. And it was because of conditional spending that the additional language with respect to drinking was added. We'll go into that in a little bit of detail. Then Anthony, very interestingly, points out that with all of this going on, there's the opportunity for popular sovereignty confusion, if I can coin a phrase. That is, the idea that, well, we should look to our local officials to affect federal policy. We should look to federal officials to affect local policy. The second part is an interesting one because it arises out of the idea that someone or some group or some interest or point of view who wants to make changes within the 50 states with respect to social policy, for example, has a choice. They can succeed in some states and not in others, in which case maybe half a loaf is all they get. They can go to the expense of making 50 visits to 50 state legislatures, or they can do some one-stop shopping by going to Washington, D.C., in which case they get a federal policy that hopefully will affect all 50 states